and too soon to say. But obviously pretty gutted about the decision. We thought it was going to go our way, but it certainly has proven that there was no way to win this through the courts. Someone had told me that beforehand. Yeah, the decision has been a surprise as well as not a surprise.
The moment Prince Harry stormed out of that courtroom, everything changed. What the judge said next will shock you. Royal insiders are calling it the biggest mistake of his life, and the price he's about to pay is absolutely insane. We're talking millions. But here's what nobody's talking about. What his brother William did years ago that makes Harry look completely foolish. The royal family is furious. Meghan is reportedly devastated.
Well, for a start, the only time that I've come back to the UK is sadly for funerals or court cases, with the odd charitable function where I can in between that. I put myself at risk for that, but I will continue on with a life of public service, so I will always support the charities and the people that mean so much to me. I can't see a world in which I would be bringing my wife and children back to the UK at this point.
And the bill Harry just received? It's enough to make your jaw drop. This wasn't simply another day in court for the Duke of Sussex. This was the culmination of what he had publicly described as one of the most important legal fights of his life. A battle against newsgroup newspapers over allegations of phone hacking and unlawful information gathering that he claimed had stretched back nearly 2 decades. Harry had invested significant time, money, and personal capital into this case, viewing it as part of a broader mission to hold the British tabloid press accountable for what he characterised as years of invasive and damaging behaviour. The stakes were extraordinarily high. According to legal analysts familiar with high court litigation, cases of this magnitude typically involve costs running into the millions of pounds. Harry wasn't just risking his reputation or his time. He was putting substantial financial resources on the line, resources that would be at risk depending on how the court ruled on various preliminary matters before any trial could even begin. To understand what happened that day, we need to look at what was actually being decided. This wasn't the final trial itself, but rather a crucial preliminary hearing focused on a technical legal issue that would determine whether large portions of Harry's case could proceed at all. The question before Mr. Justice Fancourt, the judge presiding over the matter, centred on something called the limitation period, essentially the legal deadline for bringing certain types of claims to court. According to multiple sources present in the courtroom, there was a specific moment during the proceedings when the atmosphere shifted dramatically. Legal proceedings, particularly at this level, often involve lengthy technical arguments and careful examination of documents and precedents. But those who spend time in courtrooms learn to read subtle signals, the body language of lawyers, the tone of a judge's questions, the silent reactions that reveal how proceedings are actually unfolding. Several witnesses described a moment when Harry's legal team appeared to have a realization. It wasn't announced dramatically. There was no outburst or visible panic. Instead, there was what one observer called a quiet exchange between the barristers, a brief moment of eye contact that seemed to communicate something significant. One of the senior lawyers was seen leaning slightly forward, and there was a noticeable shift in posture among the legal team. What had prompted this? Reaction was a line of questioning from the judge. Rather than engaging with the broader moral and ethical arguments that Harry's team had been making about press behaviour and the impact of alleged hacking on his life, Justice Fancourt had focused on something far more procedural. He was asking about dates and timelines, specifically questioning why these claims were being brought now, so many years after the events in question allegedly took place. This focus on timing, rather than the substance of Harry's complaints, appeared to catch some by surprise. Harry had given extensive testimony about his experiences, about feeling watched and pursued, about the emotional toll of what he believed was systematic invasion of his privacy. His legal team had presented arguments about the broader cultural problems with tabloid journalism and the need for accountability, but the judge's questions kept returning to a much narrower point. When did Harry know about these alleged activities, and why had he waited so long to bring legal action? For those unfamiliar with how the English legal system works, this might seem like a minor technical detail. But in reality, it's often these procedural questions that determine whether a case can proceed at all. Under English law, there are strict time limits for bringing most types of legal claims. These limitation periods exist for several reasons. They ensure that cases are brought while evidence is still fresh and available. They provide certainty and finality, and they prevent people from facing legal action over matters that happened in the distant past. According to legal experts, the general rule for the type of claims Harry was bringing is that they must be filed within 6 years of either the wrongdoing occurring or the claimant discovering that they had been wronged. This creates an obvious problem for claims about events that allegedly happened 15 or 20 years ago. Harry would have been well outside this normal time limit for much of what he was alleging. Harry's legal team had anticipated this issue. Of course, their response was to argue that there were exceptional circumstances that justified extending or essentially pausing the limitation period. Specifically, Harry had made a serious allegation. He claimed that there had been a confidential agreement reached at the highest levels between Buckingham Palace and newspaper executives. According to his testimony, this agreement was intended to keep members of the royal family from becoming witnesses in legal proceedings against the press. Harry argued that this arrangement had effectively prevented him from bringing his claims earlier because he had been told that the matter would be resolved privately and that he should wait. If this agreement existed, and if it had genuinely prevented Harry from suing earlier, then it could potentially provide grounds for the court to allow his claims to proceed despite the time that had passed. This was the foundation of his legal strategy, but it required the judge to accept that such an agreement existed and that it had actually stopped Harry from taking action when he otherwise would have. The problem, as became apparent during the hearing, was proving that this agreement existed in the form Harry described. There was no signed document. There were no emails or letters confirming the terms. What Harry was offering was essentially his own recollection and testimony about conversations and understandings from years earlier. He was asking the judge to accept his word that this agreement had been made and that it had bound him in a way that justified the delay in bringing his claims. Justice Fancourt's questions suggested he was skeptical. He probed the details of this alleged agreement, asking about who exactly was involved, what precisely had been promised, and why there was no documentary evidence of something that Harry was now claiming was so significant. The judge also noted that Harry had consulted with lawyers at various points over the years and questioned whether they had been aware of this agreement and whether it had actually prevented legal action from being taken. This is where the realization seemed to dawn on Harry's legal team. If the judge wasn't accepting the existence of this secret agreement, or wasn't satisfied that it had genuinely prevented Harry from suing earlier, then the limitation defense would stand. And if the limitation defense stood, then the vast majority of Harry's claims, all those relating to events more than 6 years in the past, would be struck out before ever reaching trial. Harry himself appeared to react to this shift in the proceedings. Observers noted that he looked down at certain points, and his expression seemed to reflect a growing awareness that the hearing wasn't going the way he had hoped. He had come to court expecting the focus to be on the substance of his allegations, on what had allegedly been done to him and why it was wrong. Instead, the proceedings had become dominated by technical legal arguments about dates and deadlines. This is one of the harsh realities of high court litigation. The legal system operates according to strict rules and procedures, and those rules apply regardless of the status or the perceived moral righteousness of the person bringing the claim. A prince arguing about invasion of privacy faces the same limitation periods as anyone else. The court's role is not to provide validation or emotional resolution, but to apply the law to the facts as presented. As the hearing drew toward its conclusion, there was a palpable tension in the courtroom. Harry had invested enormous resources into this legal battle, both financial and personal. He had framed it publicly as a matter of principle, as part of a larger mission to change the relationship between the press and public figures. But now he was facing the prospect that much of his case might not survive this preliminary stage, not because the judge had ruled on the merits of his allegations, but because of a procedural defense based on timing. When the session ended, Harry left quickly and without comment. The judgment itself would be delivered in writing, as is common with complex legal rulings. But the mood among those who had witnessed the proceedings suggested that Harry's team knew they faced an uphill battle. The judge's focus on the limitation issue and his apparent skepticism about the secret agreement defense indicated that a significant portion of Harry's claims might be about to be dismissed. When the written judgment was finally published, it ran to dozens of pages of careful legal analysis. What it revealed was a comprehensive rejection of Harry's central argument, delivered in the methodical, dispassionate language that characterizes High Court rulings. To understand why this judgment was so devastating to Harry's case, we need to examine the legal concept at its heart and why it proved to be such an insurmountable obstacle. The statute of limitations, or limitation period as it's known in English law, is one of the fundamental principles of the legal system. It establishes clear deadlines for bringing different types of legal claims. For the kind of allegations Harry was making, claims involving misuse of private information and related torts, the general rule is straightforward. You have 6 years from the date you discover the wrongdoing to file your claim in court. This isn't an arbitrary rule. It exists because the legal system recognizes that evidence deteriorates over time, memories fade, documents get lost, and witnesses become unavailable. There's also a broader principle that people and organizations shouldn't face the threat of legal action indefinitely for events in the distant past. The mathematics of Harry's situation were stark. He was bringing claims about alleged phone hacking and information gathering that he said had occurred primarily in the mid-2000s, roughly between 2005 and 2011. We're now in 2024, which means these events happened between 13 and 19 years ago. By any standard measure, this placed most of his claims well outside the normal 6-year limitation period. Newsgroup newspapers, the defendant in the case, made this point clearly in their defense. They argued that even if every single allegation Harry made was true, he was simply too late to bring most of these claims to court. This is where Harry's legal strategy became crucial. His lawyers weren't denying that the claims appeared to be late. Instead, they were arguing for what lawyers call an extension or disapproval of the limitation period based on exceptional circumstances. The heart of this argument was Harry's testimony about a secret agreement that he claimed had been reached between Buckingham Palace and newspaper executives. According to Harry's evidence to the court, this agreement had been made at the highest levels, involving senior palace officials, executives from the newspaper group. The alleged deal, as Harry described it, was essentially a non-aggression pact. The royal family would agree not to pursue legal action against the newspapers and would not become witnesses in phone hacking cases brought by others. In return, the newspapers would supposedly acknowledge wrongdoing at some future point and provide compensation to affected members of the royal family, but on a timeline that suited all parties involved. Harry's account suggested that this agreement had been struck at Sandringham, the royal estate in Norfolk. He testified that he had been told to hold off on taking legal action, that he had been assured the matter would be dealt with quietly and appropriately, and that pursuing litigation would only cause unnecessary damage to the institution of the monarchy and its relationship with the press. Harry portrayed himself as someone who had wanted to sue much earlier, but had been constrained by this institutional arrangement, effectively prevented from accessing the courts by the very family structure he was part of. If the judge accepted this account, it could potentially provide grounds for what's legally known as equitable relief from the limitation period. English law does recognize that in some circumstances, limitation periods can be extended or disapproved if there has been fraud, concealment, or if the claimant was under some form of disability that prevented them from bringing their claim. Harry's argument was essentially that he had been prevented from suing by this agreement, and therefore the normal time limits shouldn't apply to him. The problem was one of proof. Justice Fancourt's ruling made clear that the court needed more than just Harry's testimony to accept the existence of such a significant agreement. The judge examined the evidence carefully and found it wanting on multiple levels. First, there was the absence of any documentary evidence. Despite Harry's claims about a formal arrangement involving senior figures on both sides, no written record of such an agreement could be produced. There were no emails, no letters, no memoranda, no signed documents of any kind that confirmed the terms Harry was describing. The judge also noted inconsistencies in Harry's own testimony about this agreement. At different points, Harry had described it in varying terms, and the specifics of who said what to whom seemed to shift. This lack of clarity raised questions about whether there had actually been a clear, binding agreement in the terms Harry now claimed, or whether there had been more informal discussions that Harry had perhaps interpreted or remembered in a particular way. Perhaps most significantly, the ruling pointed out that even Harry's own lawyers from that earlier period seemed unaware of any such agreement. If there had been a formal arrangement that was supposedly preventing Harry from taking legal action, one would expect his legal advisors at the time to have known about it and to have documented it. The absence of any such records suggested that either the agreement didn't exist in the form Harry described, or it hadn't been understood as binding in the way he now claimed. Justice Fancourt went further in his analysis. He examined the timeline of events and found evidence that undermined Harry's claim that he had been unable to sue earlier. The court noted that Harry had indeed consulted with lawyers about potential claims on multiple occasions over the years. He had discussed the possibility of legal action. He had been aware of phone hacking allegations and their relevance to him. In other words, Harry wasn't completely in the dark about his legal options, and he wasn't a person who had been entirely prevented from accessing legal advice or considering litigation. The judgment suggested, though in carefully worded legal language, that the more likely explanation for why Harry hadn't sued earlier was not some secret agreement preventing him, but rather a combination of other factors. Perhaps he had been focused on other priorities in his life. Perhaps he had initially decided not to pursue legal action for his own reasons. Perhaps the decision to sue came later, when his circumstances and his relationship with both the press and his own family had changed dramatically. This is where the judge's ruling became particularly significant for Harry's case. Justice Fancourt found that there was insufficient evidence to establish that Harry had been genuinely prevented from bringing his claims earlier by any agreement or arrangement with the palace. The judge concluded that Harry had known about the potential for claims relating to phone hacking years before he actually filed them, and that he could have taken legal action during that time if he had chosen to do so. The legal consequence of this finding was severe. If Harry wasn't prevented from suing earlier, then the normal limitation rules applied. And if the normal rules applied, then the vast majority of his claims, everything relating to alleged conduct more than 6 years before he filed his lawsuit, were time-barred. They couldn't proceed to trial. They would be struck out at this preliminary stage. The judgment made clear that this wasn't a ruling on whether phone hacking had actually occurred or whether Harry had been a victim of unlawful information gathering. The court wasn't saying Harry was wrong about what had happened to him. What the court was saying was that regardless of what had happened, Harry had missed his legal deadline to complain about it. He knew about the issues. He had access to legal advice. He could have sued earlier, and he didn't. Now it was too late. This is what's sometimes referred to in legal circles as a procedural knockout. The defendant doesn't have to win on the merits of the case. They don't have to prove they did nothing wrong. They simply have to prove that the claimant is too late to bring the case. And if they can do that, the case ends before it really begins. It's a cold, technical way to win, but it's entirely legitimate under English law, and it's a strategy that defendants use frequently when they face claims about events in the distant past. For Harry, this ruling was catastrophic. He had invested enormous resources into building a case about systematic wrongdoing stretching back nearly 2 decades. He had given detailed testimony about specific incidents and the impact they had on his life. He had framed this litigation as part of a broader mission to hold the tabloid press accountable for years of behaviour he viewed as abusive and unlawful. But now, with a single judgment on a procedural point, the bulk of that case has been swept away. The ruling left Harry with only a much smaller number of claims that fell within the 6-year limitation period, those relating to more recent alleged conduct. But even these remaining claims would now have to proceed in the shadow of this major defeat. The judgment had rejected Harry's central narrative about being prevented from suing earlier. It had found his evidence about the secret agreement unconvincing. And it had suggested that Harry's delay in bringing legal action was a matter of his own choices rather than external constraints. Legal experts commenting on the judgment noted that it highlighted a harsh reality about litigation. Having a compelling personal story or a genuine sense of grievance isn't enough to win in court. You also need to follow the rules, meet the deadlines, and provide evidence that satisfies legal standards of proof. Harry had assumed that the strength of his convictions and the significance of his status would carry weight in court. But the judgment demonstrated that in the High Court, a prince who misses a limitation deadline faces exactly the same consequences as anyone else who files too late. The ruling also revealed something about the nature of Harry's legal strategy. He had built his case around the existence of this secret agreement, making it the cornerstone of his argument for why the limitation period shouldn't apply. When the judge rejected that argument, the entire structure collapsed. It was a high-risk approach that depended on convincing the judge to accept a claim about events and agreements from years earlier without solid documentary evidence. When that gamble failed, Harry was left without a fallback position. The immediate aftermath of the judgment brought into sharp focus a particularly unforgiving aspect of the English legal system, that American observers often find surprising. Unlike in the United States, where parties in civil litigation typically bear their own legal costs regardless of who wins, the English system operates on what's known as the loser pays principle. The consequences of this rule for Harry were about to become painfully apparent. In English civil litigation, when a court dismisses part or all of a claim, the unsuccessful party is generally ordered to pay not only their own legal costs but also a substantial portion of the legal costs incurred by the winning side. The reasoning behind this rule is that defendants shouldn't have to pay to defend themselves against unsuccessful claims. If someone sues you and loses, you shouldn't be out of pocket for the expense of proving them wrong. This creates a powerful deterrent against bringing weak or speculative claims, but it also means that losing in court can be financially devastating. The scale of the costs in a case like Harry's is difficult for most people to comprehend. High court litigation of this complexity and duration involves teams of lawyers working for months or even years. At the top end of the legal profession, barristers specializing in media law and appearing in the High Court can charge fees that run into hundreds or even thousands of pounds per hour. Solicitors preparing the case, reviewing thousands of pages of documents, taking witness statements and coordinating the litigation also charge substantial hourly rates. When you multiply these rates by the many hundreds or thousands of hours required to prepare and conduct a case of this magnitude, the numbers become staggering. Legal commentators with experience in similar high-profile cases have estimated that the total costs for both sides in Harry's litigation could easily run into several million pounds. In a previous preliminary hearing in this same case, Harry had already been ordered to pay Newsgroup newspapers approximately £50,000 in costs after losing an earlier procedural argument. That was for just one hearing. Now, with the bulk of his substantive claims being struck out, the potential costs order was on an entirely different scale. Newsgroup newspapers would have incurred enormous legal expenses in defending themselves against Harry's claims. They would have instructed leading counsel, conducted extensive disclosure exercises reviewing years of documents and communications, prepared detailed legal arguments, and attended multiple court hearings. All of those costs, or at least a substantial proportion of them relating to the claims that were now dismissed, would typically be recoverable from Harry under an order of the court. Reports in legal publications suggested that Harry could be facing a bill running into the low millions of pounds just for this stage of the litigation. And this came on top of his own legal costs, which would also have been substantial. Harry had instructed his own team of expensive lawyers, and he would need to pay their fees regardless of the outcome. The financial exposure from losing on the limitation issue was therefore double-sided. His own costs plus a contribution to the other side's costs. The irony of this situation wasn't lost on commentators. Harry had publicly framed these legal battles as part of a crusade against the tabloid press, fighting to hold them accountable and to prevent them from profiting from their alleged wrongdoing. Yet through losing court battles on technical grounds, he was now in the position of actually funding the very newspapers he despised. Every time he lost a procedural skirmish, he was effectively writing a check to Newsgroup newspapers to cover their legal bills. He was subsidizing their defense against him. This raised questions about the wisdom of Harry's overall litigation strategy. Multiple sources reported that Harry had been advised by legal experts that pursuing these claims carried significant risks, particularly given the limitation issues and the challenges of proving historical allegations. Yet he had pressed ahead, apparently convinced that the merits of his case and the importance of his mission justified taking those risks. Now he was discovering that principle and righteousness don't protect you from adverse costs orders when you lose on technical grounds. But perhaps the most striking aspect of this situation emerged from documents that came to light during the course of the litigation. It turned out that Harry wasn't the only member of the royal family who had dealt with phone hacking allegations against Newsgroup newspapers. His older brother, Prince William, had faced exactly the same situation. The difference in how the two brothers handled the matter couldn't have been more stark. According to court documents that were referenced during Harry's case, Prince William had quietly settled his own phone hacking claim against Newsgroup newspapers back in 2020. This settlement happened entirely behind closed doors, negotiated privately between William's legal team and representatives of the newspaper group. The specific terms of the settlement remain confidential, but it was confirmed in court filings that William received what was described as a very substantial sum of money to resolve his claims. William's approach had been discreet and strategic. Rather than pursuing a public trial with all the Attendant media attention and personal exposure that would entail, he had used the leverage he possessed as a member of the royal family to negotiate a favourable settlement. The matter was resolved quietly, without public hearings, without William having to give testimony or be cross-examined, and without airing details of royal family communications in open court. He got his financial compensation, he held the newspaper group accountable in a tangible way, and he did it all while maintaining the privacy and dignity that the royal family traditionally prizes. The contrast with Harry's approach was impossible to ignore. While William had played what might be described as a careful, strategic game, settling at a point where he had leverage and could secure a good outcome without prolonged public battle, Harry had chosen confrontation. Harry didn't just want financial compensation. According to sources familiar with his thinking, he wanted something more: public acknowledgement, accountability conducted in the spotlight, a full airing of what he believed had been done to him and his family. Harry's approach was to pursue the matter through public litigation, giving extensive testimony in court, submitting detailed witness statements that were then reported in the media, and effectively making his legal battle part of his public narrative about his treatment by the British press and establishment. This was about more than just resolving a legal claim. For Harry, this was about forcing a reckoning, about making newspaper executives face him in court, about creating a public record of alleged wrongdoing. The problem with this approach, as the limitation ruling had now demonstrated, was that it left Harry exposed to significant risks. By pursuing the matter publicly and aggressively, by refusing to settle and instead pushing for trial, Harry had given the defendants the opportunity to deploy every available legal defense. And one of those defenses, the limitation argument, had now succeeded in knocking out most of his case. Even more problematic for Harry was that his own court filings had inadvertently exposed details about William's settlement. In trying to use William's settlement as evidence supporting his argument about the alleged secret agreement, Harry had put information about his brother's private legal matter into the public domain. William had successfully kept his settlement confidential, had handled the matter with discretion, and had moved on. Now, because of Harry's litigation strategy, details about William's claims and settlement had become part of the public court record. This added another layer to the growing tension between the brothers, a relationship that had already been under strain for years. William had demonstrated that it was possible to achieve a successful outcome against the same defendant on similar allegations without the public drama and without the legal risks that Harry had now encountered. The implicit comparison was damaging to Harry's position. If William could settle successfully and discreetly in 2020, why couldn't Harry have done something similar earlier? Legal analysts pointed out that the two brothers had access to essentially the same resources. Both had the benefit of advice from experienced palace lawyers. Both had the leverage that comes from being senior members of the royal family. Both were dealing with the same defendant and similar allegations. The difference wasn't in their circumstances, but in their chosen strategies. William had opted for pragmatic resolution. Harry had opted for public confrontation. From a purely legal and financial perspective, William's approach had been vindicated. He had secured what was reported to be a substantial financial settlement without having to spend years in litigation, without running up millions in legal costs, and without exposing himself to the risks that Harry now faced. He had achieved a tangible result and maintained his privacy in the process. Harry's approach, by contrast, had now resulted in a major legal setback: the dismissal of most of his claims on technical grounds and the prospect of having to pay substantial costs to the defendant. Instead of a payout, he was facing a bill. Instead of accountability on his terms, he had received a procedural dismissal. Instead of maintaining privacy, he had put details of his personal communications and family discussions into the public record through his witness statements. The financial implications extended beyond just the immediate costs order. Harry had funded his litigation campaign in part through the substantial advances he had received for his memoir and other commercial ventures. Reports suggested he had received tens of millions for these projects. But legal costs of the kind he was now facing could make a significant dent in those resources. Every pound spent on lawyers and every pound ordered to be paid to the opposing side was money that wouldn't be available for his family's future security and lifestyle. This raised broader questions about Harry's decision-making and priorities. He had publicly stated that his litigation was about protecting his family and creating a safer environment for his children. But the financial cost of pursuing these claims, particularly when many were at risk of being struck out on limitation grounds, meant diverting resources away from his family's actual needs and security. It was a gamble, and one that was looking increasingly like it might not pay off. To understand why Harry pursued this litigation with such determination, despite the warnings and the risks, we need to look beyond the legal technicalities and examine what he was actually seeking from the court. According to his own public statements over the years, Harry had described these legal battles as among the most important fights of his life. He framed them not just as compensation claims, but as a mission to protect his family from the same forces that he believed had contributed to his mother's death in that Paris tunnel in 1997. This framing reveals something crucial about Harry's mindset. He wasn't approaching this litigation the way most claimants approach civil cases, as a matter of seeking financial remedy for specific wrongs with quantifiable damages. Instead, he appeared to view the courtroom as a venue for something deeper and more personal. He was seeking validation, acknowledgement, and perhaps even a form of closure for traumas that had accumulated over decades. Harry's previous court testimony, given in earlier stages of related litigation, had been described by observers as unusually personal and emotional for high court proceedings. He had spoken extensively not just about specific incidents of alleged hacking, but about his broader experiences, his feelings of being watched and pursued, his anxieties about his wife Meghan facing similar treatment to what his mother had endured, and his deep-seated distrust of the tabloid media. This testimony read less like standard witness evidence and more like the kind of confessional material one might expect in a very different context. There's a pattern here that becomes clear when you look at Harry's public activities over recent years. His interview with Oprah Winfrey, watched by millions around the world, was an exercise in what's often called speaking your truth, sharing personal experiences and feelings in a format designed to generate empathy and support. His Netflix documentary series followed a similar template, presenting his narrative about his life, his struggles, and his perspective on events. His memoir carried the title Spare and delved into intimate details of his childhood, his military service, his relationships, and his grievances. All of these ventures operated in a sphere where emotional authenticity is valued as the highest currency. In the world of celebrity media and personal storytelling, the rawness of your feelings and the power of your narrative are what matter most. If you can articulate your pain effectively, if you can make people feel what you've experienced, then you've succeeded. There's no cross-examination of your memories, no requirement to produce documentary evidence of your emotional state, no limitation period on when you can tell your story. The problem was that Harry appeared to bring this same approach into the courtroom, and the courtroom operates according to entirely different rules. The High Court of Justice isn't designed to provide emotional catharsis or personal validation. It's a forum for resolving specific legal disputes according to established principles of law, and it does so through examining evidence, testing claims against legal standards, and applying procedural rules that have been developed over centuries. When Harry gave his testimony about the secret agreement and about feeling prevented from suing earlier, he was offering his personal recollection and interpretation of events. In the context of a television interview or a memoir, that might be entirely sufficient. But in court, personal testimony without corroborating evidence faces a much higher bar. Judges are trained to be skeptical, to require proof, to test claims against objective facts where possible. Justice Fancourt's focus on documentary evidence and specific dates wasn't callousness or a failure to understand Harry's emotional experience. It was the judge doing exactly what judges are supposed to do, examining whether the legal requirements for the claim had been met. The judge wasn't questioning whether Harry felt aggrieved or whether he genuinely believed there had been an agreement. The judge was assessing whether, as a matter of provable fact, there was sufficient evidence to support the legal argument that Harry had been prevented from suing earlier. This fundamental mismatch between what Harry was seeking and what the court was designed to provide helps explain the visible frustration that observers noted during the proceedings. When the judge focused on timing rather than on the substance of Harry's grievances about press behaviour, it must have felt to Harry like the court was missing the point. He had come prepared to discuss the wrongs that had been done to him, to talk about the impact on his life and his family, to make the moral case for accountability. Instead, he found himself facing questions about dates and deadlines and documentary evidence. Harry's visible reaction to the judge's focus on procedural matters, his reported look of disbelief when the questioning turned to technical issues rather than moral ones, suggests a moment of realization. The system he had turned to for validation wasn't going to provide it. At least not in the form he had expected. The court wasn't going to acknowledge his suffering as legal justification for bypassing normal procedural requirements. His status as a prince and his personal history of trauma weren't going to override the statute of limitations. This gets to the heart of what might be called Harry's strategic miscalculation. He appears to have believed that the magnitude of his grievances and the public profile of his case would somehow make the normal rules more flexible. Perhaps he thought that a judge faced with testimony from a member of the royal family about alleged press misconduct would find a way to let the case proceed despite the timing issues. If these were his assumptions, they proved to be wrong. The judgment made clear that the court was going to apply the same limitation rules to Prince Harry that it would apply to anyone else. There was no special dispensation for royalty, no relaxation of evidential standards because the claimant had a compelling personal story, no willingness to overlook procedural defects because the underlying allegations concerned serious matters. The contrast between what Harry achieved through his public storytelling in other forums and what he achieved in court is instructive. His Oprah interview, his Netflix series, and his memoir all allowed him to present his narrative on his own terms to a sympathetic audience without cross-examination or procedural constraints. These ventures were commercially successful and generated enormous public discussion. Many people found his accounts moving and persuasive, but none of that translated into legal victory when he entered the courtroom. Looking at where Harry now stands, the picture is sobering. The bulk of his phone hacking claims have been struck out on limitation grounds. He faces a substantial costs bill running potentially into millions of pounds. His attempt to use his brother's settlement as evidence has exposed details William had kept private. His allegation about a secret agreement with the palace has been rejected by the court. And all of this has played out in public, with his testimony and legal strategies scrutinized in media coverage around the world. The question that emerges is what Harry does next. He still has some claims remaining that weren't caught by the limitation ruling. He could continue to pursue those through trial, though doing so would mean further legal costs and further risk. Alternatively, he could consider whether the settlement route that worked for his brother might be more sensible. But stepping back would require Harry to accept something that seems deeply difficult for him, that the courtroom isn't going to give him what he's really seeking. The legal system can provide compensation for proven wrongs, but it can't provide emotional healing or validation of one's entire life narrative. Harry came to the High Court seeking something the court was never designed to provide. He wanted acknowledgement and a public reckoning. What he found instead was a system focused on dates, documents, and legal technicalities. The collision between his expectations and the reality of litigation has been expensive, public, and ultimately unsuccessful.